And of course, things have moved on now. We do know that the Constitutional Court has agreed to hear a further application for a rescission or a cancellation of that sentence. To discuss, we're joined by Associate Professor of Law at the University of the Northwest, Tumi Musinyane. Mr. Musinyane, thank you for being with us. Firstly, it seemed like the end of the road for Jacob Zuma. Everybody keeps on saying this is the highest court in the land. There's no appeal against the Constitutional Court. But now it's not. What do you understand about an application for a rescission of the court's ruling?
Good afternoon, Francis and the viewers. Yes, there is nothing sinister about a court having to hear its own application, the application to rescind its own judgment. But the principles that applies here, are very strict. You don't just rescind a judgment unless you need to put court into the confidence that there are factors that existed that were, consequential or were material to the court that the court had in considering them. That is just the first example. The second example where you can rescind the judgment is in instance where it was granted in your absence. Now, we all know that it's public knowledge to all of us that he refused that opportunity to come before the Constitutional Court. It will be interesting to find as to what will be his reason, not necessarily to say that, he refused to come, but now he wants to rescind the judgment.
Yeah. And
it's only interesting to hear as to what will be his reasons. But in terms of the law, based on what is already in front of us, as legal, people, we view that, in our view, there is nothing to rescind there, except if we can say that there are certain things that they got wrong. But how did now you come after to say that you got this and this wrong when you failed to, appear or have an opportunity to come and put the court in the correct fact or the challenge that is before it? It's going to be quite difficult for him, honestly, to receive that judgment. Yes, the Constitutional Court is the last court in the land. If you are not happy with it, you cannot appeal. Now it means you need to go beyond the borders of South Africa in as far as trying to appeal the judgment, not rescind. There is a difference between to rescind and to appeal the judgment. He is not appealing. He is trying to rescind it on the basis that perhaps something that was not before, that was before the court failed to do, or example, it was granted in his absence, or there is an error in terms of the law, how the court delivered the judgment. That's purely the basic principle.
So you're saying the court is unlikely to change its mind. We heard from legal reporter Karen Morn. He is expected to say he's old and this could be a death sentence. That's a very emotional argument. What do you think the court could make of that?
It is very unfortunate that these are some of the things that could have been to his advantage if he availed himself to the court and put the court into his confidence to say that in as much as prison is the only punitive, order that he can order, but look at my age, look at my circumstances, look at my health, look at the country the way it's going at the moment. Perhaps think of something else, instead of me committing me to a prison. These are things that he could not, put in front of him. He could not really gain the opportunity. It's too late for him now. So what is left is only the Correctional Service Department that can now determine whether he sends him to prison or not. But he can only be paroled, I think, after he serves a quarter of his sentence, about 8 months, around October. It's only then that perhaps, the Correctional Service. But unfortunately, the Constitutional Court has done its job. It has put down a sentence. It's now up to the Correctional Service how to effect that sentence. Is
it not significant that the Constitutional Court has agreed to hear his application, though?
There is nothing sinister or there is nothing wrong. Anyone who feels aggrieved by a judgment issued by the court has an opportunity to approach the same court to rescind or to appeal. In this instance, they cannot deny him. It's a right that exists to everyone else. It is not to say Zuma was the first one to rescind the judgment of the similar court. It's normal within the law to do that. There is nothing wrong with it.
All right. In the meantime, Do you understand, because now this is a debate, we're hoping to get full clarity through the course of this show, but does it mean he still has to hand himself over, or does it mean the order that he hands himself over in 5 days is suspended? We heard from Karen Morn he is planning to go to the Pietermaritzburg court on Tuesday to stay his arrest, so maybe that'll play out and he won't be arrested. Does that court have jurisdiction? How does it all work?
Now, remember now, he's in KwaZulu-Natal. So the Justice Khampepe, the order that is his committal order that he signed, says he must be in KwaZulu-Natal. So if there is anything that Zuma needs to do to stay that arrest, it means he has to apply to the Pietermaritzburg High Court to stay the committal sentence, or for him to hand himself to prison. And the reason for that being that I am still exercising my right to rescind the judgment. So until such time that there is a judgment, an order, in as far as my application for rescission is concerned, can I not be arrested? Can I not hand myself to the correctional service prison? So it is up to the Pietermaritzburg court, not necessarily to review the sentence or to hear the appeal of the Constitutional Court decision, but merely to say that can we stay the arrest until such time that I'm able to exercise my right before the same court that gave me this sentence.
All right, so that'll play out on Tuesday. So do you think it's unlikely he will be arrested, because the deadline is tomorrow, but then police have 3 days. So surely everybody will wait and see how the court process plays out before moving. Do you agree?
Yes. It means that he should have, by the time, or he needs to inform the prison authorities that I have filed an application to stay this arrest. So can you perhaps wait until the court has made a determination? So it means that until such time, once the correspondence is received by the prison, they cannot do anything until such time that the prison, the Constitutional Court has made a ruling in as far as the decision is concerned.
All right, so we're expecting some clarity this week, firstly on whether or not he has to go to jail. In the interim, the Constitutional Court will hear his application on the 12th of July. There's also been a development on the side of all of this. The Chief Justice, Mogoeng, basically stepping out of the picture, which means that Raymond Zondo is the Chief Justice, but he's, of course, the chair of the Zondo Commission that is in legal argument with the former president. So is it all pretty clear-cut now that there will be a clear line between him, even though he's a Chief Justice, he will still be on loan, as it were, to the Zondo Commission and not really dealing with the business of the Constitutional Court? This doesn't create complications, does it?
Not necessarily, Francis, because remember he's acting Chief Justice of the Constitutional Court, not necessarily as far as Jacob Zuma's case is concerned. So I believe what was likely to happen is anything that involves Jacob Zuma's application or case, he will have to recuse himself from that because he is part and parcel of that litigation. So he will remain the acting Chief Justice in all affairs of the Constitutional Court. But in as far as Jacob Zuma's case is concerned, he is likely not to be involved, directly or indirectly. He is likely not to be involved.
All right, thank you so much. Bringing much clarity there, the Associate Professor of Law at the University of the Northwest, Tumi Musinyane. Well, the